I'm Brett.
And I'm Alice.
And we are the prosecutors. Today on The Prosecutors, we continue our coverage of the Derek Chauvin trial, and it's the defense's turn to put on evidence. Hello, everybody, and welcome to this episode of The Prosecutors. I'm Brett, and I'm joined, as always, with my charming co-host, Alice.
Thanks, Brett. That's so nice. I definitely thought you were going to say spitty co-host.
I would never do that to you, Alice. I mean, I did leave that review, but other than that, I wouldn't call you out here on the podcast in front of everybody.
No, you wouldn't call me out on that. Certainly not.
Yeah, I mean, you're decent. You're a decent co-host. Perfectly decent. I can't remember exactly what it said. Anyway.
I'm naive. I'm naive and biased. Right, something like that.
The joys of podcasting means you get to get a lot of reviews, and not all of them are nice. So, but that's fine. We don't care. We just roll with it. Because we're here for you guys. And if Alice has to be a little spitty to get her message across, that's fine. That's all. It's really the content that matters. So, and that's what we're all about here is content. So thank you to everybody who stuck with us and Alice's spittiness through this trial. We're really getting to the end of it now, guys. The prosecution rested. The defense is ready to put on its case. The defense is only going to take a couple days. In fact, as we are recording this, the defense has rested, and we are getting ready for closing arguments, and then this case will be in the hands of the jury. By the time we finish this podcast, you should know the defense's argument. You already know what the prosecution has said. You'll know what the defense has said, and you can make your own decision about whether or not Derek Chauvin's guilty of anything, and if he is guilty, of what exactly he is guilty of. So with that, I think we should just dive into the defense's case. So after the prosecution rest, the defense opened up its case with a witness who was a Minneapolis police officer who testified about an incident in May 2019. Now, this is an incident involving George Floyd, a prior incident in which he was arrested under the influence of drugs. This is another thing that has really irritated people. We've talked about this before, how, as many people have said, George Floyd's not on trial. And some of you may be asking, we've said over and over again, what happened in the past doesn't matter. It might matter if George Floyd was on drugs that day, but it shouldn't matter what happened in the past. And this testimony was actually put on for a very limited purpose. This is one of the things about trials. We've talked about it before. Oftentimes, the rules are kind of ignorant of the way real people think about things. The jury is admonished by the judge that they are only to consider this evidence for possible effects of drugs on George Floyd. So how George Floyd might act when under the influence of drugs. And this goes to whether or not he was under the influence of drugs that day, and whether or not his behavior was consistent with being under the influence of drugs. That's important because if he was under the influence of drugs, it both goes to the reasonableness of what the officers did and may also go to the cause of death. The jury is not, and the judge said this specifically, the jury is not to take this as an impeachment of George Floyd's character. But I think we all know they're hearing about another incident where George Floyd was under the influence of drugs, and in fact, where he resisted some police officers. This is seen on body-worn camera. And during this encounter, Floyd was arrested in a vehicle, not unlike what we have in this case. During his arrest, Floyd begged not to be arrested, and he eventually resisted arrest. At some point, the police officer is telling him to show his hands. He does not do so. In fact, he starts to sort of put his hands down around his waist. It's a really bad thing to do. At that point, the officer actually draws his weapon. He's now screaming at Floyd to show his hands. This is pretty bad. It's a pretty bad video. It obviously doesn't put Floyd in a very good light. And also during this arrest, Floyd was shown to put something in his mouth, which goes to this question of whether or not he did that in this arrest as well. Now, on cross-examination, the prosecution took this on head-on because they pointed out some things. They pointed out that, yes, it is true, Floyd did initially resist arrest, much like he resisted arrest in this case, to the point that the officer is yelling at him, drawing guns. At one point, he threatens to tase him. But George Floyd didn't end up on the ground. He didn't end up with anybody on top of him. The police didn't cause him to have some sort of medical event. Now, the prosecution never says this explicitly, but the message is clear that, okay, fine. George Floyd's had other run-ins with the law. Guess what? He didn't end up dead during those incidents.
Now, Michelle Mosing testified next, which was also about the May 2019 event. Mosing was the paramedic who responded to the incident that day. The judge made the same admonition to the jury that they should only consider this with respect to how drugs may have affected Floyd and not to his character. Floyd's blood pressure that day was 216/160. This is incredibly high, and this actually resulted in Floyd having to go to the hospital. Now, on cross, the prosecution elicited similar testimony that Floyd was able to walk and talk and didn't want to go to the hospital, and his respiration was normal. He did not stop breathing that day. His heart didn't stop. He didn't go into a coma. Again, the message is clear that even though this is an encounter with the police, one that he may have been on drugs for, one where he resisted arrest, but it ended very differently.
And you can see, we've talked about the back and forth of a trial a lot, and you definitely see that happening here. This is a circumstance where there's a lot of discussion by the defense. The defense is trying to show that during encounters with the police, Floyd's heart rate is going to be elevated. His blood pressure is really high to the point that he did have to go to the hospital. Obviously, the implication is the same thing probably happened here, but maybe this time there was just a few more drugs, or the adrenaline was just a little higher, or a year later, Floyd was in worse health, and so he just wasn't able to survive this encounter. And then the prosecution comes back and says, yeah, but the other thing that didn't happen is nobody put him in a restraint. Nobody kneeled on him for 9 minutes, and because they didn't do that, even though his health's not great and his heart's not great and he's got some blood pressure issues, he walked out of the hospital that day. And the implication obviously is, had Derek Chauvin not done what he did, George Floyd would have walked out of the hospital or the police station or whatever that day. So now the defense has played a few things from 2019, and obviously there's the stated goal of showing George Floyd's reaction, and there's the other goal that is not stated and not permissible to reinforce in the jury's mind that George Floyd resists arrest and that he has been on drugs for a while. The defense moves to the day in question, and in fact they call a woman, Shawanda Hill, who was with George Floyd that day. Shawanda was George Floyd's ex-girlfriend, but they were on friendly terms, and they actually ran into each other at the Cups Foods. And Hill described Floyd as happy and perfectly normal in Cups Food. In fact, he offered to give her a ride because he knew that she didn't have a ride back to her house. When they were in the car, though, something happened. Now, Miss Hill was not allowed to testify to any potential drug use on the part of George Floyd. She didn't actually witness any drug use, and she's not an expert in drug use. So it's not like she can testify, he was definitely on drugs because his pupils were dilated or whatnot. But they sat in the car for a while she was on the phone. And an interesting thing happens during this period. At some point, Floyd falls asleep while she's on the phone. She tries to wake him up, but she's actually not able to do so. After a lot of effort, he does wake up, but he mumbles something and then falls back asleep. She tried a few more times to wake him up and was unsuccessful. At this point, people from Cup's Food had actually come out to the car because they were trying to get them just to pay for the stuff that they had taken. They'd obviously given them a counterfeit. I think if they could deal with this without involving the police, they would have been happy to do so. But Floyd just wouldn't wake up. And it wasn't until the police show up and aggressively wake up Mr. Floyd that he finally does come fully back to consciousness. Now, although the defense doesn't make this point at the time, I think this is an argument they will make later on in closing. We've heard testimony before that one of the things that happens when someone is under a heavy dose of fentanyl is they fall asleep. They can't be woken up. And that's one of the reasons that the oxygen level can plummet in someone who is on fentanyl, because they're not just asleep, their body is shutting down, their breathing is becoming very shallow. So that is obviously something the defense wants to point out. Now, in cross-examination, the prosecution, they focus more on Floyd's demeanor in the store. He did a little dance out to the car. He was in a good mood. He wasn't in a combatant mood. And they also focused on the fact that Floyd at no point had complained to Miss Hill about chest pains, about shortness of breath, about having any problems at all before the police arrived.
And this is really interesting because, as we've said, you can kind of begin to lose yourself in the testimony and forget again that this case is actually about Chauvin. As you can see, the defense is really focusing completely on Floyd and what happened that day and what his drug use was in the past. And there hasn't even been a mention of Chauvin so far in the testimony. And I think that is what they are going for right now. Now, next, the defense calls Peter Chang. Chang is with the park police. Chang was on scene that day, assisting the other officers. His job was just to monitor what the passengers were doing while the police dealt with Floyd. Because of Chang's distance from the event, his body cam gave a wider field of view than some of the other cameras. Now, the defense played this video with the intent of showing the growing crowd and their growing anger. Chang testified that he began to grow concerned about officer safety. He described the crowd as very aggressive. In his video, Ms. Hill, who we just talked about and had previously testified, can be heard saying that Floyd should just get in the car, that he is fighting with the police, and that she doesn't understand why Floyd is behaving the way he did. The direct is good for the defense, as it's the first time we've heard a police officer defend what the other officers were doing, even if he is not allowed to speak directly to that, because he has not been qualified here as an expert on the use of force. Remember what the prosecution's done. The prosecution has aligned itself with the police, and you heard witness after witness in the prosecution's case in chief saying, this is what a normal or reasonable officer who's trained well in our force acts, and then there's Chauvin. But here, for the first time, we hear from another police officer who was directly there, commenting on the fear for officer safety.
And you wonder, this is interesting. I think there's some real interesting psychology to this. All the other police officers who've testified up to this point have been supervisors, the chief of police, the lieutenant. These are guys who were the supervisor of Chauvin, and they've all basically said what Chauvin did, violated department policies, that Chauvin is a bad cop, et cetera, et cetera. This is the first sort of line officer who's testified, and his testimony is much more consistent with what you'd probably expect from an officer. He comes in and he basically says, yeah, it was a tense situation. It was getting more tense all the time. I was concerned about officer safety. The crowd was growing very angry. Mr. Floyd was resisting. I didn't see anything unusual. I mean, it's just much more what you would probably expect an officer to say. Question how valuable it is for the defense, whether or not it'll go far in the minds of the jury. But you always have to remember, with juries, you don't really know what they're looking for, particularly if you're a defense attorney. You don't know if you've got somebody on that jury who is really just looking for an excuse. They're really just looking for an excuse to vote one way or the other. We talked about this when we talked about Temujin Kinsu and the absurd theory of the prosecution that he had flown to commit a murder because there was no way he could have driven there. And even though there was no proof he had flown, Nevertheless, it was an excuse that jurors could use and sort of say, well, he's got this ironclad alibi, but he could have flown. They did tell us he could have flown. So maybe that's what he did. And I think that is similar to maybe what's going on here. The defense is sort of giving, if there is a person on the jury who really wants to believe this is a justified use of force, here's a police officer saying it was.
But also notice how the defense had to plan, had a long game. So it knew who it was going to put up in its case in chief, this police officer who was a line duty officer. And remember back to the cross-examination of some of the supervisors and how the defense brought out in their cross-examination that the supervisor had not walked a beat for many, many years. In other words, trying to begin to build in the jurors' minds, there's a difference between supervisors and line officers who face kind of the fear, the safety issues on a daily basis. And it's not just pie in the sky theory, but boots on the ground practice. And Chauvin is a boots on the ground practice. So think back to how I think it was week 1, the defense was already starting to pave a path for witnesses that it knew it was going to put on.
Yeah, that's a really good point. And it just goes to show how much preparation and thought goes into a trial like this.
Next, the defense recalled a prosecution witness, Nicole McKenzie, who is the medical support coordinator who trains officers in first aid. Now, this isn't uncommon to call a prosecution witness, but it's not exactly common either, because as you can imagine, typically you have witnesses whom you are calling because they are very good for your side. And so if you're calling a prosecution witness as the defense, you as the defense think there's something that McKenzie can say that will help you. And the jurors may think that also. They may think, well, they already testified for the prosecution, but now they're testifying for the defense. And there could be some psychology there where maybe the jury begins to question, they may give more importance to a witness who's already testified for the prosecution, who then testifies for the defense, because they think, well, the prosecution thought they were good for them, but they're actually good for the defense. So it's risky to do this, but you see it once in a while. You have to be very sure about what you're calling the witness for. So the defense had tried to get into her expertise in things like excited delirium during cross-examination during the prosecution's case in chief. But because it went beyond the scope of direct, the defense was not allowed to pursue these questions. Thus, he called the officer as part of his case. Now, one of the other officers had received excited delirium training and had mentioned it during the incident with Mr. Floyd. This condition has symptoms like psychosis, incoherence, superhuman strength, etc. Now, excited delirium is caused by things like cardiovascular disease, drug use, and mental health issues. It's often described as the person just, quote, snapped. Now, on cross, the prosecution noted that when someone is in excited delirium, they're supposed to put the defendant in the side recovery position, something that did not happen here. Excited delirium can exacerbate problems like those that Floyd suffered from. But interestingly, the acronym for how to deal with this is not a crime.
Yeah, it's like in the training, they're really trying to emphasize to the officers when someone does this, they're just having a medical issue. So don't treat them like a criminal. Don't shoot them, for instance. And I tell you what, I don't know that we will cover the other officers' cases because covering a case in real time is actually really hard. But I'm interested to see what happens with them because those officers at various times said things to Derek Chauvin that seemed as though they were trying to get him to follow procedure. One officer, we talked about this yesterday, 2 different times said, should we move him on his side? And Chauvin said no. This other officer who had specifically received this training from this witness said, I think this might be excited delirium, which once again, Mr. Chauvin has had that training as well. And the whole point is, maybe we should back off here. It feels like one thing that happened here, Chauvin was very clearly the person in charge. In fact, I think he was even training one of the officers who was on the scene. And the other officers, and we'll see what kind of criminal liability they may have for this, did not feel as though they were in a position to force Mr. Chauvin to do anything. And so they were consistently trying to urge him to do something consistent with their training. Now, the defense is trying to use this to just say, look, someone recognized he might be under excited delirium. Excited delirium leads to things like superhuman strength and psychosis and all sorts of bad things. And that would be a reason why Mr. Chauvin felt like, I can't get off of Mr. Floyd. I have to stay on him because he's in the midst of this delirium. So that's sort of what they're going for here, but there's definitely, it's a double-edged sword, and this testimony really was a double-edged sword, and I thought that not a crime acronym was a really sort of powerful moment for the prosecution. So the next two witnesses for the defense are really their main defense. If, you want to watch something from the defense case, but you don't have time to watch the whole thing, these two witnesses are the main thing to watch. Now, you won't be saving much time because they also took up the vast majority of the defense's case. Remember, we've talked about this before. There are two aspects to whether or not Chauvin is guilty. Did he use unreasonable force? Did that unreasonable force cause Mr. Floyd's death? The prosecution put on a lot of evidence on both sides. Now the defense is going to attack that directly, and they're going to start with their own expert on force. This expert was a man named Barry Broad, and he was someone who was an expert in use of force. He's a former police officer. He has over 30 years of experience, and he has reviewed the use of force in over 100 cases and has testified many times in cases involving the use of force. Now, he also pointed out that he has been retained many times where he has reviewed the case file and did not testify because his conclusion was that the use of force was unjustified. And in fact, the defense sort of elicited this, so they couldn't really get into it, that Broad did consult briefly with the Minneapolis Police Department. So there's even a possibility that he, at one point, was going to be a witness for the prosecution. In any event, Broad testified that Chauvin had acted reasonably in his use of force. This was probably the most controversial witness who testified for the defense. A lot of people online, a lot of the experts on television really lambasted him because he was very full-throated in his defense of what Mr. Chauvin did. He went through the Graham v. Connor factors, which we've talked about before. He started with the severity of the crime. Now, this crime is not particularly severe. It's just counterfeiting a $20 bill. And so what he did, sort of effectively until the prosecution pointed it out, was he elided that. He kind of said, well, yeah, the initial crime wasn't that serious, but really what's more important is the conduct of the individual when they are first contacted by police than the initial crime, which is not exactly what the Supreme Court said. You can imagine, kind of like in this case and other cases we've seen, we really don't want the police killing someone, accidentally or not, over a very minor crime. Now, on imminent threat, Mr. Broad pointed out that the officer really only needs a reasonable fear. The threat itself doesn't have to have shown itself yet. So if the officer has a reasonable fear, for instance, we talked about that previous encounter with Mr. Floyd, where Mr. Floyd's hands were down around his waist. Now, he didn't have a gun in his hand. The police officer didn't see a gun, but he had a reasonable fear that the way Mr. Floyd was acting and where he had his hands, that he could have been reaching for a weapon. And that meant that drawing his firearm, which in of itself is an act of force, was justified. Shooting Mr. Floyd at that point probably wouldn't have been justified, almost certainly wouldn't have been justified, but pulling his firearm was. And that's sort of what Mr. Broad is going for, this reasonable fear of a legitimate threat. On resisting and evading, which was another aspect the Supreme Court talked about, Mr. Broad testified that the officer may escalate his response to the individual's resistance, and he testified that everything matters, including what was going on in the immediate environment, which is exactly what the defense wants, because the defense has really been focusing on this growing crowd and its growing anger at what it's witnessing with Mr. Floyd.
Broad testified that what Chauvin did was not deadly force, even though Floyd died. He used an example to clarify this point. Quote, I'll give you an example that I used to teach my academy classes. So officers respond to a domestic violence situation, and the suspect is still there. And he fights with the officers, and the officers are justified in using a taser to overcome this person's noncompliance. They tase the individual, and the individual falls to the ground, strikes their head, and dies. This is not an incident of deadly force. That's an incident of an accidental death, and in my review, I would like to see whether the suspect resisted and was objectively reasonable. Now, Broad testified that police are not required to fight fair. If the suspect resists, officers are allowed to use reasonable force to overcome that resistance. Broad agreed with the prosecution that Chauvin's initial use of force was justified, and that at the initial point, he would have been justified in using a more serious use of force. He also testified that any resistor, handcuffed or not, should be taken to the ground in the prone position.
Yeah, Broad was a big fan of the prone position. So all we've heard about is how bad the prone position is, that the prone position is liable to kill somebody, that it cuts off all your air, that you shouldn't do it, you should go to side recovery. The problem is, that is true, and this is where this case gets a little tricky, because you put someone in the side recovery position after they have ceased resisting, and that's one of the reasons that although the 9 minutes and 29 seconds, the entire thing is something the prosecution focuses on, what it really focuses on is towards the end, when Mr. Floyd passes out, when his pulse has stopped. At that point, it's really hard to argue that he shouldn't have been put in the recovery position. So this is something where the defense is sort of eliding that point. They just really want to say most of what Chauvin did was perfectly justifiable. And I guess if they can push that far enough in the timeline, then if towards the end something bad happened, maybe there'll be a juror who says, well, he should have stopped earlier, but so much of what he was doing was justified. We're really going to say that he's guilty of murder. So this testimony was very solidly in Chauvin's favor. And, one thing somebody emailed us and asked, if you have two experts who testify on the same issue and they disagree, isn't that reasonable doubt? Because how do you know who to believe? You're not an expert, and you're listening to these two people, and one of them says X and one of them says Y. Well, which one's right? And that's a really good question. It comes down, in most cases, to credibility, and who does the jury think is more credible? In this case, you've got Mr. Broad, who is a hired expert, and he's up against a lot of high-ranking members of the Minneapolis Police Department. It's one reason, as Alice was talking about, that cross-examination on those people was so important in pointing out that, they haven't really been out there in a long time. And so how much do they really know? You really have to get at their credibility in a fundamental way. So what the prosecution tries to do when they are cross-examining Broad is kind of make him say dumb things. Make him say things that seem so ridiculous that they just can't be true. At one point, for instance, in his testimony, he describes Floyd as resting comfortably on the ground. And the prosecution's like, he's resting comfortably on the asphalt? And this is a weird thing to say, right? It just doesn't make sense. And it's those little things that can really undermine a witness. And the prosecution does a pretty good job when they're cross-examining Mr. Broad. So they use the video, and they use the things that happen across the 9 minutes and 29 seconds we've talked about so much to get the expert to back off on some of his more strident statements. I mean, in his direct, he is basically saying that what Chauvin did, he doesn't say this, but the implication is almost he would teach this in his academy classes. Like, this is perfect. This is exactly what you do. And frankly, I think that hurts him because he never in the direct admits any error at all on Chauvin's part. In cross, the prosecution's able to get him to admit some of those things. So for instance, he had said that putting your knee on someone's neck is not a use of force. The prosecution went through, showed various times when Chauvin had his knee on Mr. Floyd's neck, and Broad was basically forced to admit, okay, that is a use of force. At that point, that is a use of force. They also were able to get Broad to agree with the prosecution's view on positional asphyxia, and that the position Floyd was in did put him in greater danger of that. They also went through the Connor factor. So the defense had done that. The prosecution comes back and they point out that Mr. Broad really basically skipped the first factor. He tried to go straight to resistance, and that's not the first factor. The first factor is, what was the crime? And this is a relatively low-level crime. In response to Floyd saying he could not breathe, they were able to get Broad to say that a reasonable police officer could have thought that maybe Floyd was having trouble breathing, particularly given his drug use. And they knew he was on drugs. They mentioned it several times in the video. And Broad acknowledged that the use of force must be reasonable from beginning till the end and cease when the danger to the officers has also ceased. And he acknowledged that Chauvin's use of force never changed, not until the moment when the paramedic walks up to him and moves him off of Mr. Floyd so they can begin treating him. Well, look, I mean, I think that kind of is where this case comes down to. At some point, Mr. Floyd, I mean, he's non-resistant. He's basically dead at one point. He's passed out at another. Was there a point where Chauvin, why would he feel as though he's still under threat at that point? I think that's one reason the defense keeps harping on this crowd thing, because they're trying to have the crowd sort of interject itself as the danger. The Floyd danger is gone, and now the crowd danger is there. At one point, the prosecution actually gets Broad to say something, like I said, you want to make him say dumb things, and they get him to say that there is a point where Mr. Floyd is clearly trying to breathe, or he's clearly trying to move himself in position to breathe, and Broad tried to say that was an example of him being non-compliant. The prosecution's like, so trying to breathe, in your view, is non-compliance. And that's the kind of thing that chips away at the credibility of an expert.
And, this is a really good example of why you want a witness who comes off balanced. So while Broad is testifying on direct for the defense is probably doing fist pumps, right? Broad is squarely in Chauvin's corner. He's squarely saying everything he does is reasonable. So much so, though, that he doesn't really concede things that can lead him to sound ridiculous on cross-examination. And so this is true for not only testifying witnesses, this is true for lawyers in argument. You as a lawyer need to know when to concede. There are times you need to let things go. You need to know what you can concede without losing your argument, right? And this is true for the witnesses. You have to be able to sound reasonable to the jury or to the judge so that you don't sink with the ship on something small, but you take your entire argument with you. So it's kind of an interesting balance you need to strike with your witnesses. Of course, you want someone who's passionate about your side and who can really tell your story, but you need someone who can also stand up to cross-examination and not kind of, begin to lose credibility for not conceding points that they should. Now, Dr. David Fowler testified next. If Broad was called to contradict the prosecution case that Chauvin's use of force was inappropriate, Fowler was brought in to contradict Dr. Tobin. He even had an accent, having been born in South Africa. Now, Fowler formerly was a medical examiner for the state of Maryland. Fowler testified that Floyd died of a heart attack brought on by a combination of his enlarged heart, blocked arteries, use of methamphetamine and fentanyl, possible intake of carbon monoxide from being on the ground near vehicle exhaust, and his altercation with the police and the attendant adrenaline that came from it. Fowler brought up what we referred to as the San Diego experiments earlier, the one that Tobin attempted to pre-butt. In those studies, people were hogtied and had weights of up to 200 pounds put on their back. These studies showed no danger of positional asphyxia. Fowler challenged Tobin's assertion that these studies were flawed. In fact, there were 23 studies that supported this position. Several of these studies looked at every example of the use of the prone position in 4 cities. In those thousands of examples of officers putting people in the prone position, like in Floyd's situation, none of them resulted in death. The only death from positional asphyxia they could find was from someone who was not in the prone position. Fowler also testified that even if he used both knees, he would only have transferred around 35 to 40 pounds of weight, not the entirety of his weight as Tobin had testified.
As Alice said, Fowler is really brought on to challenge Tobin. I said earlier, if you watch anything, watch Fowler and watch Mr. Broad. I actually think at the end of the day, this entire case comes down to Fowler versus Tobin. I really think which one you believe is where you go. Fowler was really good. You can already see he's good. He seemed competent. He seemed like he knew what he was talking about, and he went directly at Tobin. And Tobin is the best testimony we've seen yet, and he went directly at him. And he was asked, in terms of the placement of Officer Chauvin's knee to Mr. Floyd, is it your opinion Mr. Chauvin's knee in any way impacted the structures of Mr. Floyd's neck? Now remember, Tobin had said that the knee was compressing Floyd's neck to the point that he was essentially breathing through an opening the size of a straw. Fowler says, no, it did not. None of the vital structures were in the area where the knees appeared to be from the videos. Fowler went on to state that there was no evidence from the autopsy of injury on Floyd's body from the knee. Injuries that you might expect if that knee was the cause of Floyd's death. For instance, and we've all heard this, when someone is strangled to death, there is often bruising around the neck. In fact, there's bruising in the shape of the person's hands. There's finger bruising around the neck, and it's a similar thing here. The idea that if Chauvin has his knee on Floyd's neck for 9 minutes and there's so much weight that it's actually choking him, that there should be some evidence of that in the autopsy. There should be some bruising. There should be some bruising, and we didn't see that here. And Fowler went directly at Tobin, saying that there were no studies that supported his contention that the compression of the hypopharynx, remember we talked about that a lot, could cause hypoxia. And this led to numerous objections from the prosecution. It was actually interesting. Every question that Fowler was asked, there was an objection from the prosecution. They were all overruled, and it was almost the lady doth protest too much, where the prosecution was kind of showing its hand that it was worried about this testimony by objecting over and over and over and constantly being overruled. Now, Fowler also testified that the sudden decrease in Floyd's condition from struggling and speaking to unconscious was more consistent with a sudden cardiac event than a hypoxia. He testified, the heart is vulnerable because it's too big. Remember, Mr. Floyd had an oversized heart. It demands lots of oxygen. It has very narrow vessels. Remember, one of Mr. Floyd's aortas was 90% blocked. There are certain drugs that are present in his system, methamphetamine. And remember, we learned earlier that methamphetamine further constricts the vessels. And he already has one that, as I said, was 90% blocked. There's another drug, fentanyl, that slows down your breathing. And this was another interesting thing. You remember from Dr. Tobin. Dr. Tobin took the video and he actually counted Floyd's breaths. And he said that is the exact rate of respiration you would expect from somebody who was Mr. Floyd's age and weight and condition. Well, Fowler said that's a problem because given the struggle that Mr. Floyd is involved in, his rate of respiration should have been much higher. It should have increased dramatically, and we don't see that. So Tobin saying that it's normal is actually a problem because it should have been more than that. And the combination of all these things as Mr. Fowler said, quote, will slow down the oxygen saturation in your blood. We've got the carbon monoxide, which has the potential to rob some of that additional oxygen capacity. We have multiple entities that are all adding to each other and taking away from a different part of the body's ability to get oxygen into the heart. At some point, the heart stopped pumping blood effectively. And once again, that is consistent with what you heard from the medical examiner, right? I mean, the medical examiner basically said this was a heart issue. Now, he does say that it's as a result of officer action, where this gentleman is saying, no, it's all this other stuff. But you can see how the defense is going to try and use this testimony to put a seed of doubt in the jury's mind. They don't have to convince you that they're right, just that it's possible.
Now, to the extent the restraint played a role, Fowler stated that it would have caused him stress and added to his adrenaline. Interestingly, although Fowler indicated that he thought that this was a heart event, he concluded that the cause of death was actually indeterminate. Quote, When you have so many conflicting different potential mechanisms of death, the manner is not clear. This would be bad for a prosecutor, but it's exactly what the defense is looking for. It's doubt about what the actual cause of death would be for Floyd. Remember, the defense doesn't have to show how Floyd died definitively. They just have to sow doubt that Chauvin was the cause of the death. Now, on cross-examination, the prosecution was able to undermine some of Fowler's testimony. Fowler did admit that he'd seen no evidence of carbon monoxide, but he qualified that answer by saying it had not been tested. He also noted he didn't know for sure that the vehicle that was near Mr. Floyd was on. He also acknowledged that although Floyd had no injuries showing asphyxia, that was not all that uncommon. In fact, in a, quote, substantial number of the cases, there is no evidence of physical trauma when asphyxiation is the cause of the death. The prosecution also scored a point when Fowler stated that Floyd should have been given immediate emergency attention when he began to suffer cardiac arrest. Chauvin gave no attention to Floyd, regardless of what killed him. Now, the prosecution also questioned Fowler on whether he did calculations about the reserve oxygen in Floyd's body, something Tobin did explicitly. Fowler said he was not a pulmonary expert and would defer to them on that question. Now remember, Tobin was a pulmonary expert, and what Brett said earlier, it comes down to what you believe, Fowler or Tobin. And here the prosecution was able to get Fowler to back off and to show that maybe their expert, Tobin, was the expert that the jurors should listen to because of his expertise in pulmonology. Fowler also agreed that the leg raising we've discussed before was consistent with hypoxic seizure, just as Tobin also testified. So what the prosecution is trying to do here is to actually show that Fowler agrees with Tobin more than the defense wants to let on.
Yeah, and it's interesting because it's kind of the opposite of what we were just talking about with the last witness. Fowler, I think, actually does score some points for his credibility by acknowledging these things. He doesn't fight them. When the prosecution asks these questions, he says yes. When they ask whether Mr. Floyd should have gotten medical attention, he's like, yes. He's very clear about that. So he scores some points for his credibility, but as Alice said, there are many times where his answers seem to indicate that Dr. Tobin really knows what he's talking about. And in some particular cases where Dr. Tobin is far more qualified to comment than he is.
Absolutely. And so this is actually a great tactic for any attorney, making the battling expert give credence to your expert. Fowler took up an entire day of testimony. The court also considered some legal issues. Maurice Hall took the stand and formally invoked the Fifth Amendment. The judge excused him from testifying, and the defense also made the standard motion for judgment of acquittal, which was denied. And we know it was denied because the defense ultimately put on its case. A judgment of acquittal happens after the prosecution rests, and the defense essentially argues its legal case, saying there's no need for the trial to be given to the jury because on the law, the prosecution has fallen short of their duty to meet the elements of the charges. But that was denied.
And I saw some people kind of freaking out about this online, and they shouldn't be. This is a standard thing. It happens in every trial. It's actually required for you to be able to bring certain appeals. So, it's no big deal. He was always going to make that argument. It was always going to be denied. So don't really read anything into that either way. Now, the final day of testimony started with two very interesting things. The first one was Chauvin chose not to testify. This was actually the first time we'd heard from Mr. Chauvin in this trial, obviously outside the presence of the jury, but he was questioned by both his attorney and the judge on whether or not his decision not to testify was well considered, was his own, and if he was certain that that was what he wanted to do. This is very common because every person who's ever been convicted will eventually claim that they really wanted to testify, but their lawyer kept them from doing it. And so it is standard practice in just about every court I know of that when the moment comes where the defendant is either going to testify or not testify, there is a very lengthy discussion on the record where he's asked again and again and again if he's sure, and again and again and again he says that he is. One thing to note about testifying in your own defense and why it often doesn't happen. If you testify, there are a couple things that happen. Number one, because you are the witness, your credibility as a witness is very important. And so many things, many past actions, many things that you've done wrong, anything that would go to your credibility can suddenly come in for that purpose. Now, the jury will be told this is for the purpose of determining the witness's credibility, but as we've said, very difficult for people to block that off in their mind. So we know, for instance, that Mr. Chauvin has had some previous use of force incidents. We know that the judge kept those out. If Chauvin had testified, those things might well have come in. It's actually something that the defense attorney said to Mr. Chauvin while they were having this colloquy, that if he testified, the prosecution would be able to ask him about just about anything with almost no limit. So that's one reason most defendants don't testify. The second reason is if you testify and you lose, basically no appeal will ever succeed because the laws in every state essentially say that if the defendant testifies and the jury convicts, the assumption is the jury listened to that defendant, did not believe him, and convicted him. So basically, any other evidentiary issue or hearsay over here or an objection that was overruled over there that shouldn't have been doesn't really matter in the eyes of the appellate court. You testified and you lost. The downside to testifying is so massive that you really don't see it that often unless it's a really desperate situation.
I think you're absolutely right. We often hear defense counsel, we ask ahead of time if their client is going to testify. And almost every single time, the defense counsel, whether it's a show or not, says something to the effect of, I'm telling him not to, but he really wants to.
And I think that's a natural reaction. I think it's natural for people to want to testify, guilty or innocent, to get up there and try and convince the jury that you didn't do it. I think that's a natural thing. So it's not surprising, but most people at the end of the day realize this is not going to go well for me. And I think the defense has done a good enough job of at least, I don't know if they've introduced doubt, but they've at least introduced the possibility of doubt, that it wasn't one of those things where Chauvin needs to get up there and convince that jury that he was terrified for his life. There's enough that they've done that they might be able to win without his testimony, and his testimony has so many downsides. The second interesting thing that happened is we had a real, honest-to-goodness discovery issue in the flesh, in action. You guys are all interested in things like Brady versus Maryland and discovery requirements, and we had that here. And we've talked about discovery many times and how the prosecution has to disclose all its evidence to the defense ahead of time. Well, in this case, that didn't happen, and we don't allow sandbagging. There was a late discovery issue in this case, and that can result in that evidence being excluded altogether. The prosecution tried to argue that they had newly discovered evidence that blood tests had been conducted on Mr. Floyd, and those blood tests had shown no carbon monoxide in his blood. As we just talked about, when Dr. Fowler testified, he testified that it was possible that carbon monoxide had played a role here, and that if it had, it would have been one of the contributing factors to Floyd's death. But he said, we can't know for sure because there were no tests run. There were tests run. They just were never turned over to the defense. The prosecution said they were never turned over to them either, and they had found out about them the night before, and they classified this as newly discovered evidence that they should be able to bring out to refute Dr. Fowler on rebuttal, because now it's the prosecution's turn. The defense has rested. The prosecution's either going to rest too, or they're going to put on rebuttal witnesses, and they wanted to put on rebuttal evidence about this carbon monoxide. The judge was displeased, I think, to say the least. This judge is very sort of even-keeled. He never seems like he's angry or upset, and he didn't seem like he was angry or upset at this point either. But what he told the prosecution at the conclusion of this was that if they even mentioned the carbon monoxide test, he would declare an immediate mistrial. So all this would just go away. We'd have to start over. That's how seriously he took this.
And you have to understand why. As a judge, there's a reason that he would get heated about this, because you don't want any sort of unfairness on on any trial. But especially with this one, it's being watched by everyone. It's being live streamed. People are tweeting about it. There are podcasts about it. This is at the core of kind of the unfairness issue and why we have strict discovery rules, so that there is no sandbagging. You do not want a Perry Mason moment in the courtroom in real life. There is not supposed to be a gotcha moment. It's supposed to be fair battlegrounds for everyone. And this is clearly not fair if it's coming at the last minute. Maybe the prosecution really did just find out about the test, but it kind of doesn't matter. I think what this judge did is the ruling that is the right answer, but almost every single judge who was presented with this issue would likely rule the way he did.
And you may be thinking to yourself, but isn't it more important for the jury to know that there was no carbon monoxide in Floyd's blood? Isn't that more important? In a way, maybe it is, but remember, this expert was testifying based on the information he had, and he made what was a plausible guess is maybe a pejorative word, but he made a plausible discussion. He entered into a plausible discussion about the possibility of carbon monoxide, which he could not rule out, and he admitted he could not rule in because there was no testing. So now, if all of a sudden there's a test, you're able to undermine that witness with information that he didn't even know about. That if he had, as the judge said, if he'd had, he wouldn't have said that. That was one of the things the prosecution's like, well, we should be able to rebut this because he said this. And the judge said, well, if he'd have had that test, he never would have said that because he would have known. And that's true. And to allow the prosecution to do that on the back end like that, when, as the defense said, this guy was on a plane flying back to Los Angeles. He was in the middle of the air. He didn't even know this was happening. And they're going to try and bring in somebody to rebut this. That would be completely unfair to Chauvin and would raise so many concerns that the judge was willing to declare a mistrial right then.
Now, with that ruling and that understanding, Dr. Tobin was still called by the prosecution on rebuttal. Dr. Tobin testified as to the carbon monoxide, carefully limiting his testimony. He testified that because Floyd's blood oxygen level was 98%, the most his carbon monoxide could have been was 2%. The normal range is 0 to 3%. They then moved on to the hypopharynx. Fowler had argued that the literature did not support the idea that compression of the hypopharynx led to lower oxygen levels. Tobin stated that the research was there, but that it was based on the scientific research rather than clinical research. Tobin argued that it was essentially self-evident that narrowing the hypopharynx by placing pressure on the neck would reduce oxygen levels, and thus there had not been any studies on it. And with that, the prosecution ended its rebuttal testimony and the trial came to an end. The judge gave the jury Friday off, and closing arguments were set for Monday. The jury was to be sequestered when deliberations started. Remember earlier there was a motion to sequester the jury after the Minnesota shooting, the officer shooting that resulted in a death, and the judge declined then. However, here he does decide to sequester the jury once they are handed the case, so after closing arguments and after the charge is read to the jury.
So with that, the testimony came to an end. And that means that all the evidence that's going to be presented in this case has been presented. There are still the arguments, and I'll be interested to see what the arguments are. I'm particularly interested to hear what the prosecution says about the second-degree murder charge. I'm interested to hear how they argue that they've met all the elements there. I think there's enough evidence there that I think they might be able to get to it, though they never really felt like they were going for second-degree murder. It always seemed to me that this was much more a third-degree murder or second-degree manslaughter. I'm going to listen. We're going to listen to the closing arguments. We'll probably do a follow-up on that. Honestly, by the time you hear this episode, we may have a verdict. But I'm going to step out on a limb and tell you what I think is going to happen. So I'm saying this before we have a verdict. I think that the prosecution has shown that Floyd's death was largely a result of what Derek Chauvin was doing. Was it entirely because of Derek Chauvin? No, I think all these other things played a role. But I do think it is true that had Chauvin not engaged in this neck restraint, Floyd wouldn't have died. Now, maybe he wouldn't have died if he weren't on drugs. Maybe he wouldn't have died if he didn't have an enlarged heart. All those things. But I don't think that means that Floyd gets off, or excuse me, that Chauvin gets off if you just show that there were other contributing factors. And I think the experts testified to that there are often secondary reasons for someone's death, but there's a primary reason too. And I think the primary reason here was the actions that Chauvin engaged in. I also think it is very difficult to argue that what Chauvin did was reasonable from beginning to end. And I think that's the key. It's not necessarily the beginning. And it's not even necessarily the first 5 or 6 minutes of the 9 minutes and 29 seconds. But there are multiple times where other officers are saying we should put him in the prone position. Mr. Floyd at one point loses consciousness. A minute later, he doesn't have a pulse. The officers actually check his pulse twice. He doesn't have a pulse either time. I don't understand why Chauvin never moved. I can't wrap my head around it. And the danger of the crowd just doesn't, I don't understand that either. I don't understand how the crowd's growing hostility is enough for him to continue to put Floyd in this position where clearly something bad is happening. When the man doesn't have a pulse, this is a bad situation. It's time to act. And I think that's why at the end of the day, third-degree murder is what the jury is going to do. And I'm going to read you the elements of third-degree murder again. Whoever, without intent to effect the death of any person, causes the death of another person by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life. I think when Chauvin refused to move from Floyd for the entire 9 minutes and 29 seconds, and even when the EMTs arrived, basically the EMTs had to move him, had to tell him, okay, it's time to move. That, to me, is the kind of thing that is imminently dangerous and was obviously imminently dangerous to him because of the reaction that Floyd was having. And I think for whatever reason, and I don't know why it was, I don't think Chauvin intended to kill Floyd. Prosecution didn't either. They didn't charge him with any intentional murder. But for whatever reason, it just seems like Chauvin had decided he was not going to move from that position. And I don't know if that was because the crowd was getting angry and he was just showing them, like, no matter how mad you get, I'm doing this and I'm not moving. And it didn't matter what the other officers were saying. It didn't matter what was happening to Mr. Floyd. So in my mind, I think the most likely outcome here is third-degree murder. Now, I will say I will not be shocked by second-degree manslaughter just because second-degree manslaughter seems like kind of a slam dunk here. And I'll read you the elements again on that. Whoever by their culpable negligence creates an unreasonable risk and consciously takes the chance of causing death. Given all the evidence we've heard about the prone position and the training the officers receive and what was going on, it's difficult to say that Mr. Chauvin wasn't being negligent, at least in this case. So the jury is going to have to determine all these facts and then decide which of these charges the facts fit. And that's the one they will choose. So if I had to say what I think will happen here, I think third-degree murder is the most likely outcome.
Well, you've given everyone a lot to think about. I have no idea if our listeners are going to be able to listen to this before the jury reaches its outcome. Here's something for those of you who may not be familiar. Once the jury gets the case, there are really no rules that govern them other than that they're sequestered in this case, but they get all of the evidence back there and they are left to their decision. They are not being watched. They can ask questions to the court. It's in writing typically, but they cannot speak to witnesses. They cannot speak to attorneys. They can only speak with each other, and they do not have to tell the court how they reached their decision. Now, because of that, because you have 12 people deliberating, jury deliberation is a black box in the sense of how long it could take. It could take very little time. It could take days, weeks. With a case this size, it went on for multiple weeks. Likely jury deliberation will take some time just to go through all of the evidence. And so that's why we don't know whether you will be hearing this before the jury has reached a verdict or not. No one really knows when they will reach a verdict.
Well, like I said, we're going to follow up on this and discuss the prosecution's closing arguments and the defense closing arguments and see what they say and see how they do. And obviously, once the jury makes its determination, try and make sense of that one way or another. I know there are probably a lot of people who have a lot of thoughts, questions, and comments. Love to hear your view on this. Look, I know this is a really controversial case, and they're very heated and passionate about it. We've tried to share this information as unbiasedly as we can. And I'll tell you, coming into this case, Alice and I, we're prosecutors. We work for the police all the time. I have a bias towards the police. I'm not going to hide that. It's just a reality. I see these guys going out there working hard and doing good all the time. And I think a lot of times they don't get the respect they need. And a lot of times they get criticism based on what some bad actors do that the average police officer doesn't deserve. And so I probably came into this case with a little bit higher threshold than maybe the average person. I also, Alice knows this, I also tend to just be a devil's advocate and a curmudgeon. So if everybody's saying one thing, I'm always like, well, what about the other thing? And, I was open to Chauvin being acquitted here. And I was open to thinking this is an injustice that he's even on trial. I was open to all that. And it has been eye-opening and enlightening for me to listen to all this testimony and to see all this testimony. Not everybody's going to reach the same conclusion I've reached. I know that. And I hope that people, whatever they think about this, can respect each other and respect each other's positions, because we need to talk about this stuff more. It's something Alice said at the very beginning of us covering this case. One reason we wanted to cover it is because people need to talk in an intelligent way and discuss in an intelligent way the issues of the day. And if all we do is yell at each other and hate each other and demonize anybody who has a different opinion, then we're in trouble. And we're in trouble as a society. And I know I said I wasn't going to preach to you, and I'm not preaching now. I'm just saying. We think it's important, and we wanted to share this with you, and I hope you guys have enjoyed this coverage. And you can let us know. Hit us up at prosecutorspod@gmail.com. Find us at prosecutorspod on all your various social media. We're on Reddit. We're on Facebook. We're everywhere. We're everywhere and anywhere you want to talk to us. If you want to leave a comment on YouTube, if you can find these videos, because YouTube apparently doesn't like people putting up videos about this, but you can leave a comment there. Otherwise, reach out to us anywhere. We want to hear from you. Leave a review on Apple. Come see us at CrimeCon, which is coming up pretty fast, so you need to buy your tickets. Don't forget, prosecutors for 10% off. We'd love to see you. Well, Alice, do you have anything else before we sign off?
No, but thank you all for trusting us with this discussion and for sticking with us. So we appreciate you as always, and appreciate your civil discourse on our comments on social media and also your emails to us.
And we're going to follow up on this case, but next week we'll have a new case for you guys. So if you're sick of all this, we'll have a new case for you that you guys can enjoy. But until then, I'm Brett.
And I'm Alice.
And we are the prosecutors.
Brett Fowler. No, Brett. That's you, sorry. I was like, who's Brett Fowler? Brett Fowler was there. Read cue cards. Applause. Laugh endearingly. Okie dokie artichoke. I've never heard that.
Really?
No.
Yeah. Okie dokie artichoke.
Well, now I have. Okay, you're on speaker.
Okay.